associate, the ins and outs of vendor due diligence. Thanks for spending some time with us today. We'll do our best to make it worth your while. I'm Angie Yazelitis, and I'll be moderating today's session. Today's session is actually the second in a series of 3 that will be brought to you by Reclamere and Rosen-Simon. What I'd like to do is I would like to go through some reminders before we get started. To let you know, we're going to present today in a conversational format, and basically what that allows us to do is to open up then at the end to continue with some questions to really bring you into that conversation, and we hope to be able to get to all of your questions. Please feel free to go over and please feel free to send those questions over to me using the question feature in your GoToWebinar panel. What we'll do then is we'll also follow up with all registrants and attendees to answer any questions we may not have had time to address, and we're going to be providing you with some additional information. As we noted during the last webinar, some assumptions regarding the general knowledge of what is covered under HIPAA has been applied to this webinar. So please know that if you need additional information, we can also schedule time with you in our follow-up attempt. Lastly, this webinar is being recorded, and we'll provide the link to you in our reach out so that you can share that information with other members of your team or certainly with your network. I'm very proud to present to you today Angie Singer-Keating and Renee Martin. I'm not going to spend a lot of time on their bios today because we really went into those during the last session. But as expert speakers on this topic, combined, they actually bring over 35 years of professional experience in data destruction, data security, and related topics. And for those of you who joined us for the first webinar, you know that Reclamere is a data security company offering a full range of specialized IT asset management and information security services. And together we offer several educational opportunities like this throughout the year. So we hope that you'll join us in the future. I do think it's important to note that Angie and Renee work closely together to provide exceptional and affordable full-service consultative and legal work in regards to what we'll be covering today. And I think you'll have a sense for their complementary work as we move forward with today's presentation. So with that said, I'm going to go ahead and get started. You can see on the screen the agenda that we have set up for today. I'll start with just a very quick review of what we covered in Webinar 1. And then we'll get into really what should be in a business associates agreement, how you can negotiate the correct agreement, a little bit on how to protect your organization during a breach with topics like, who really is responsible, and we'll look a little bit at how to vet your vendor process around the business associate agreement. Now, during Webinar 1, I'm not going to read this off to you, but we really looked at the expanded definition of business associate, made some clarification, looked at the mandated provisions, and talked about really that whole breach risk assessment, which we'll get a little bit into today, and how the enforcement works. I'm going over that with you right now because I think, if at the end you want additional information, the recording of the first webinar in this series is available to you, and I certainly will follow up and make sure that if you don't have the link to that we get that to you after today's session. The reason that we chose to really take a deep dive into the business associate agreement during this particular webinar is that under the omnibus rule, and you may know this, a critical part of regulating business associates and subcontractors really happens with that business associate agreement. So obviously it's a critical part of this discussion. And the fact is that subcontractors are also now a point of focus for both the covered entity and their business associates. The business associate agreement really has to satisfy both the business associate process as well as processes that may involve their subcontractors. So, it can get complicated. You may recall that we covered this information during the first webinar. I'm not going to read this to you. The reason that we really left this on the screen at all is to remind you that these important points are actually the very first necessary step in reviewing any business associate agreement. They're pretty black and white. These are things that have to be included in a business associate agreement. Again, we went through these one by one in the first webinar, so we're not going to spend a lot of time on that. But it's a starting point. This is where you start. There's actually 10 very specific points that must be included in a business associate agreement. So with that said, if you're missing any of this information, you already know that you may have a potential problem. What we're going to do today is we're going to focus most of the discussion on areas that aren't quite as clear as these 10 parts of a business associate agreement. So Angie, what I'd like to do is move the conversation into the more gray areas of the business associate agreement development. And that really is what should be included, not what must be included. Can you talk about why it's important to move beyond using a simple template or just following the steps that were on the last two slides with our attendees today?
Sure. I think I get asked maybe once or twice a week. I can't speak for Renee how often she gets asked, but I get asked for, well, can't you just give us a template? Or in the course of performing a risk assessment or risk analysis with a client, they will say, well, this business associate agreement we used, we downloaded a template from a particular professional organization maybe, or some type of online HIPAA help center type of thing. And it really is important post-omnibus that the agreement is crafted in such a way that, yes, it must include those topic areas that we've already covered, but more importantly, there needs to be some specificity based on the type of electronic health information that your business associate is going to be handling, their use of subcontractors, and if they do use subcontractors, you may want to add even more specificity around those provisions. And then on top of that, there are things to consider, such as the format of the electronic data, where if it's in the cloud or if it's held in custody of another party where we get into the subcontractor role, all of those types of things should be specifically addressed to the specific covered entity and the specific business associate in question. And that's why it's so very important and why I refer clients to Renee when they tell me they have a template and I look at it and I see that there are issues. And Renee can really speak to the legal side of why the customization is so important.
Sure. Of course, for me, the first thing that I consider is whether or not I'm drafting the business associate agreement for the business associate or the covered entity. So obviously, if it's for the covered entity, I try to give them the most protection, and if it's for the business associate, I like to give the business associate the most protection. And then it often becomes a negotiated process from there. As we said earlier, some things are not debatable or negotiable. There are those 10 elements that have to be in there. But beyond that, there is wiggle room to include certain provisions to protect the parties. One of the things is an indemnification clause. And the indemnification clause means that if you're harmed by a breach or some other action of the covered entity or the business associate, depending on who you are. And right today we're looking at business associates. So the covered entity would want to have some kind of an indemnification clause in there if the business associate is the one that's responsible for a breach or a loss of data or information. And the cost of notification, believe it or not, even that should be considered, and who's going to notify individuals who are provided services by the covered entity. Also involved in that then is I like to know whether or not my covered entities have cyber insurance, and it's very, very important that I see the policies that they're looking at, because insurance policies are often difficult to read. They sort of are disjointed, and you have to be sure what kind of coverage you're buying for yourself. I also, if they won't accept, if the other party won't accept an indemnification clause, then I will try to put in a liquidated damages clause. And what that means is, if there is a breach or a loss of data, that you put a cap or a dollar value on that, and that would be what the other party would owe to you should that event occur. And the average cost for damages or I shouldn't say the average, it really is a wide range depending upon whether you're talking about a small covered entity or a large covered entity. And I did some research, and the damages actually range from $10,000 to $1 million, depending upon, as I said, the size of the entity. So that's something that I would take into consideration in looking at the liquidated damages clause. And the other thing to consider and to factor into that is, generally when I've had clients who have experienced a data breach, and we generally offer the covered entity, I think it's only responsible to offer the patients or the clients of the covered entity to reimburse them for the cost of looking at their credit ratings, et cetera, for a year or so. So per victim, that usually costs about $18,000 according to my research. You also need to look at the cost of an investigation, to hire somebody like Angie to come in and look and see, where the breach occurred. So that goes into the factoring for the liquidated damages. And also the cost of notifications. It's not cheap. If you have quite a few individuals that you have to notify of a breach, just the mailing costs themselves, or if, God forbid, it be over 500 people, placing that information in your local newspaper, et cetera, is expensive. So that's why it's important to get an indemnification clause and have that be your first priority, and then to include, if you can't get that through negotiations, then to at least get a liquidated damage clause and try to figure out, based upon, things that are in the in publications and in research done by others, what you think that liquidated damages should be.
Okay. So talking about how liability plays into that, the idea of scope of liability, from what I understand, is very broad. You need to know who your business associates are, and then you need to address the liability and the due diligence process with each of them. And so, Angie, I know for you, vendor due diligence is really a big part of vetting your business associate agreement. Can you share your thoughts on why vendor due diligence is a critical part of this process?
Sure. It really is absolutely crucial. The business associate agreement requires certain things. However, oftentimes, and particularly smaller companies or lesser informed companies, will simply sign the agreement because they have to in order to do business. It's not really something that they feel like they can negotiate, or that it's just another contract that they sign. And unfortunately, when you have a small company providing services to a much larger company, sometimes these business associate agreements are getting signed by these vendors without them really understanding what it is that they're committing to. And so when we look at things around, does the business associate have business continuity plans? Do they have incident response plans? Do they train their staff? And later on, we're going to get into some really crucial issues around encryption and lost and stolen devices. The vendor due diligence is so crucial because we already have the financial services industry to look to for kind of a reasonableness standard. The financial services industry, they've been doing vendor due diligence for 15 to 20 years now. And if you are a vendor who provides services and you work with financial information, you can expect that your client is going to want you to do some type of attestation, or maybe they're going to want you to actually allow them to come in and perform an audit on you. So that vendor due diligence step is really crucial. And I think that when that vendor due diligence is not done and there is an incident that occurs, that's where we get into the legal issues of where we go back to this business associate agreement, and then we rely on folks like Renee to come in and interpret everything. And oftentimes there can be some surprises for both parties. So, Renee, can you share some of your thoughts on why vendor due diligence is so important?
Well, I think, it's becoming more apparent, unfortunately, as we hear more and more about data breaches in the financial sector, as you've said. The healthcare industry is becoming actually a significant target for hackers and those who want, not the healthcare information, obviously. I don't think it's as relevant that Mrs. Smith had a cholecystectomy, but the hackers would like to know what their social security number is, their tax ID number is, let's say, their credit card information is. So I think we have to get, as healthcare providers, as covered entities, more sophisticated about who we do business with. And, the due diligence process has always been in place when you have the liability associated with acquiring another provider. And that's the type of process now that we are advocating, I think, is essential when you determine who you're going to have as your business associate. Shame on you, actually, if you don't know who you're utilizing as a vendor, and then you find yourself in a position where you weren't aware that the business associate was a good corporate citizen or very consistent or aware of what their HIPAA responsibilities are now that the Omnibus Act has been passed. And unfortunately, I'm still seeing too many people, too many clients of mine that just jump into signing the business associate agreement so that it's done, and it's something that they feel like they can just tuck away without really doing enough due diligence on who their business associates are. There's certainly, as Angie said, questions that you can ask, surveys that you can send to the business associate about how many breaches that they have experienced to date. You could check the OCR's wall of shame to see see if their name is there and how large or how small or how frequently their name comes up. See what they're willing to provide you or what you can negotiate with them over the course of the business associate covered entity relationship, as far as allowing you to come in and do checkups on their systems. And this is where somebody like Angie would come in and see how well they're handling your data. So in this day and age, it certainly behooves the covered entity not to play ostrich and not to be naive enough to think that everyone is going to be doing what they should be doing even though the business associate is now separately liable. They might not be monitoring their subcontractors, and they might not be fully aware of what their requirements are. I wanted to get back to one point. The business associate and the subcontractor, the theory that the Office of Civil Rights bases that liability on is that the covered entity and the business associate is acting as the agent of the covered entity. And the same theory would apply between the business associate and the subcontractor. So when someone's an agent of yours, that means that you have a certain amount of direction and control over that organization or individual. So I always include in my covered entity business associate agreement that there is not a agency relationship, but that in fact the covered entity and the business associate are independent contractors. So that's one way, at least, to sort of minimize the OCR's look back to the covered entity based upon what the business associate has done. But that's not absolute silver bullet to protect you from liability, obviously, when the OCR comes in and may look at each of your actions separately and determine liability for both parties.
So, Renee, if you don't mind to keep going here, I know we've talked about what happens when your due diligence actually uncovers some concerns and you feel, or the covered entity or the organization feels like there should be a termination of that business associate relationship.
Well, first off, I hope we haven't entered into a relationship with a business associate that we should not have, and that's why the due diligence is so important. And I want to also add that generally speaking, the term of the business associate, remember the business associate is providing the covered entity with services of some type or other, whether it be legal, actuarial, an accreditation agency, an accounting agency. So the whole idea is the business associate is providing services to the covered entity, so there's an underlying agreement somewhere that defines those services. And the business associate agreement is incorporated, or I incorporate it by reference, into the underlying agreement. So the term of the service agreement and the term of the business associate agreement are the same generally. So when the contract ends for the services, the business associate agreement ends, and that's usually when a lot of the triggers come in for what the business associate is supposed to be able to do with the data that you've provided to them over the course of the underlying agreement. Termination for cause, that should be spelled out in the agreement, but generally speaking, it would be a material failure of the business associate to be able to perform their basic services that they are to provide to you. And under the business associate agreement, if they fail to meet what HIPAA's requirements are, that is grounds for termination. And when the agreement terminates, that's where it becomes very important when looking back at when you entered into the agreement to understand and to do your due diligence as to where the business associate is actually housing your data and your information. And then what's the process then for disentangling that? And I guess Angie could speak to that since that's more her area of expertise than mine, but that's certainly part and parcel of the mandatory term that's in the business associate agreement.
Yeah, at the end of the need for the useful data, at the end of the contract termination, this goes into an entire area of complexity that we could do an entire webinar series, 3-part series on. The very first thing is that this requirement to terminate when a business associate is not in compliance and they've had this this material breach of contract. Oftentimes what I see with my healthcare clients is that they are working with vendors that are absolutely mission critical to the organization, to patient care, and it is very difficult to simply say, okay, well, you're out of compliance, and therefore that's a material breach of our contract, and we're going to have to terminate our contract with you, because we're looking at patient care, and it can be very complex with interconnected IT systems and infrastructures, and very challenging. That's on that technical side of what does it look like if you know you should be getting rid of a vendor, but they're mission critical at this point. So then we move into an area where we are going to terminate. We do have another vendor in the wings, and we know how to switch over without impacting patient care or anything mission critical to the organization. Well, what are the obligations of the business associate to destroy that information at the end of this term? And that's, again, one of those areas where, in my opinion, more specificity in the business associate agreement is really called for, because there are a whole lot of ways that people dispose of data. They will donate it. They will donate hardware to a charity without properly sanitizing drives. They will send things to a local scrap metal recycler. How is it that you, as a covered entity, what parameters are you going to set upon this business associate to make sure that when it's time to dispose of this information, it's done properly? One very quick thing that you can do is to require that the business associate and their subcontractors use a NAID AAA certified data destruction company, preferably one that carries special downstream data liability coverage, so that at least there is some independent oversight and accreditation around the destruction process, and that you kind of get that kind of extra kind of oversight of this business associate for when the data needs to die. And then we get into the virtual world of virtual servers, where hardware is going to stay in place, but what are going to be the controls around how the data is destroyed electronically or digitally in virtual worlds or remote data centers and things like that? Another rule of thumb in that regard is to require that whatever the type of data destruction, that it be done in accordance with NIST Special Publication 888, Revision 1, and that covers every kind of data destruction, from sanitization, overwriting, degaussing, shredding, and every type of media. So it's really important that everybody's on the same page with what the basic standard minimum of care is, whether for the vendor credentialing through NAID AAA certification, or whether it's through a baseline controls of a globally recognized organization like the National Institutes for Standards and Technology, stating how data should be destroyed at the end of its useful life.
And I would say that if you mention NIST to a business associate and they don't know what you're talking about, that's an important due diligence red flag right there.
Yeah, I think that's a great point, Renee. In any of these situations, when you start talking about any of these things that Renee and I are discussing, and someone literally doesn't know what you're talking about, that is a giant flashing neon sign that you may have a business associate who does not fully understand their obligations under HIPAA as it relates to the security rule, privacy rule, and protection of your information as a covered entity.
And Angie, do you have more concern for a business associate that says they'll house the data in perpetuity as opposed to one, because that's one of the options, and that's allowed for under HIPAA. And I get the sense that's more dangerous when someone says, oh, that's all right, I'll just keep it. And I'll watch over it.
That's a great point. You know, on one hand, when you take your data outside of your custody and you put it in the custody of a data center, whether that's in the cloud, meaning out there somewhere in the world, or it's down the street in a data center, you're giving that custody over. And so on one hand, that can mean that you're giving it over, especially if you're a small business, you're giving it over to an organization like one of the tier 1 cloud providers like Google or the Amazon cloud, where they're able to provide security and all kinds of attestations of their security controls. So you get this highly secure environment that's way more secure than anything that the vast majority of small to mid-sized businesses could have on their own. But on the other hand, you do have all of this gray area of how long will my data be stored, and what is in my service level agreement with these cloud providers. And the other thing to really understand and make sure you know is that if you are giving custody of your data over to a data center or some other type of cloud service provider, that they're not just a reseller of someone else's hosting. You want to make sure that you're dealing with the people who actually have your data. We've had security incidents that we've worked with our clients where they thought their data was in a data center in Texas. However, once there was a breach, they found out that the software provider for the electronic health record software was there, but their data actually lived in a whole other state with a subcontracted data hosting center. And that was a really ugly situation where there was a known breach. There needed to be notification, but all of the requirements for an investigation so that we could understand root cause and business impact analysis and everything else was completely, was just an unbelievable mess, because all of these parties, the covered entity, the business associate, and now this unknown subcontractor, are all fighting over whose fault this is and whose responsibility it is. So, yeah, that's a very excellent point, Renee.
So it also sounds like you're saying that one of the due diligence questions should be, for instance, I've had cloud providers function as business associates, and I have incorporated into those agreements that the data can't be housed. I didn't have a problem so much with it being held in the United States, but I had a concern that it would be held in a third world country or in India or somewhere outside of the United States, where I wasn't sure whether or not HIPAA and our requirements would be applicable. So I presume where the data is going to be housed would be an important question to ask the business associate as part of the due diligence.
Absolutely. That is so, so crucial.
Okay, next slide.
Yes, I mean, it's interesting because from what I understand, the whole evaluation process that you're kind of talking about, which is part of due diligence, is still really an evolving area. So, Angie, what can you share on that process as a whole?
You're right. It is evolving. I point back to the financial services industry where we're not inventing the wheel when we talk about vendor due diligence and vendor management. They have great models in place. One of the things is to understand that you have obviously limited resources to be auditing or personally going to business associates and evaluating their organizations. And so there are things that you can do. One of the first ones is that you can look at high-risk areas in the context of a particular business associate. So for instance, a business associate that may be coming on site, accessing your systems while they're in your building. While they may have access to an incredible amount of information, they're in your building, accessing your systems that you control. On the other hand, contrast that with a business associate. One of the examples I use is an attorney that maybe deals with malpractice, and they're taking information from the covered entity on external hard drives to take back to their law firm. I also see this with accountants, and they're taking thousands of records, potentially hundreds of thousands of records on an unencrypted hard drive. That's a far higher risk than this business associate who comes onto your property, comes into your systems that you control. Once that hard drive has left the organization, that's incredibly challenging. So I would want to look at that accountant. I would want to look at that attorney, that law firm. I would want to look at my vendors who handle my end of life with, taking away the old computers. I would want to look at all of those vendors that take hardware or data out of my custody to perform a service for me. Transcription services are another area. So I would risk rank my vendors. That would be the first thing. And I would risk rank them based on the custody of the data. I would risk rank them based on the number of records that they are going to control or have access to. And then I would look to the high-risk areas for healthcare data breach. One of the most interesting things in the most recent Verizon data breach report is that they give statistics on root cause analysis for data breaches by industry. And in many of the industries across the board, unencrypted lost and stolen devices are very tiny root causes. They're 5%, 7%. The statistic for healthcare was 40%. 40% of root cause analysis on data breaches were lost and stolen unencrypted devices, and that includes especially backup tapes. So here's another area where you really have to understand what it is that this business associate is doing and understand what it is that they're doing with the data throughout its entire lifetime, to then make the determination where it may be absolutely appropriate that in certain cases you're going to actually physically come and inspect and take a look at their facility. In other cases where you can't go to the Google Cloud and do any type of due diligence, you can ask for things such as an SSAE 16 attestation, which is a particular type of report that is done and is attested to by a CPA, where the financial controls have been evaluated, the technical controls have been evaluated, and all of those systems have been given a kind of a green light. When we get into smaller organizations, you can ask the business associate for an attestation that they've had a risk assessment performed. So for instance, here at Reclamere, when we've done a risk assessment for different clients who are business associates, they will ask that we prepare an attestation letter stating that we performed a risk analysis on a certain date and that they are substantially, materially in compliance with the HIPAA security rule as of an effective date to the best of our professional knowledge and belief. And that is another way that you can look for some type of attestation. The other thing that you can look for specifically in the end of life is you can ask them for their NAID AAA certification documentation, so that for end of life, that things like they are doing background checks on their employees, they're holding your material in a secure chain of custody throughout. All of those types of things are independently audited for those organizations. So those are some of the different ways that you can perform due diligence without breaking the bank.
And Angie, I think that it was very important the way you described the attestation that you provide your clients that you do a risk assessment on. I've had clients ask me, this so-and-so vendor says they're HIPAA compliant, and I would avoid anyone who says that for the most part, because that's saying they're 100% compliant with all HIPAA's privacy and security requirements, and I think that that's probably something that not everyone's going to be at all times and every moment. So I generally tell clients to sort of steer clear of someone who's making those kinds of representations.
That is an excellent point. In today's day and age, everyone wants the magic bullet. They want the magic widget that they can install on their network. They want the magic vendor who can come in and push a button for them, and presto, poof, you're HIPAA compliant. And those kinds of promises and those kinds of statements are somewhat disingenuous because there is no certification program to certify that a particular vendor is HIPAA compliant. There are certification bodies and different types of auditing organizations that will look at things and attest to them that it's maybe compliant with a CMS requirement for how medical records are handled or something like that. But to overall make any kind of claim that you're HIPAA compliant is a general kind of overarching statement is really problematic. HIPAA compliance comes down to people, processes, and finally technology. The widgets are really, they're, in most organizations, they're kind of the tail wagging the dog. And that's, most organizations go straight to the technology. They also will say that, well, we've had a penetration test, so we're HIPAA compliant with the risk assessment. And that's only really one of 79 criteria that if you're subject to an OCR audit, that they're going to be evaluating. And so HIPAA compliance, being compliant and having a risk management program in place goes so far beyond the technology and any of the technical controls that you have in place. So that's a really important distinction and a really important point that you brought up, Renee.
And I suppose if the business associate is, I guess, refusing or very reluctant to provide any of the information that you're asking for as part of the due diligence, that should be a red flag to the covered entity. Not that your request as a covered entity should be overly burdensome, but it seems like some of the basic things that we're talking about here today, if the business associate balks and says, we can't do that or we won't do that, that's probably reason enough not to enter into the relationship.
That's an excellent point.
Which, I think it kind of leads to the point that you should be as diligent as you possibly can, but no matter how diligent you are, there is still potential for a breach to happen. But I'd like to talk just a little bit about that breach notification process, as it applies to business associates versus the covered entity. And then I think if we can dig a little bit deeper and go into is it a good move for a covered entity or an organization to include their own breach notification requirements that would be shorter than the 60 days that we see on the screen? Can they even do that? So if you could give us some of your thoughts on that, I think that would be very helpful.
Sure. I think that one of the most important things to state first is that before we start using the word breach, it is really, really, really important to understand what a toxic nuclear word that is. Everything starts out with an incident, whether it's a privacy incident, whether it's a security incident, and then an investigation will then determine whether it's an incident that warrants further analysis. And not until all of that analysis, investigation, potentially forensics, until all of that has been done, can we make the determination, number one, if we've had a breach. And then on top of that, we may still need much more data processing and analytics to make a determination on what type of breach it is, whether it's reportable to OCR because it's immediately in the time frame because it is more than 500 people, whether it falls under the once a year notification, and also to take a look at an area we haven't even discussed, which is, could it be a data breach that is a violation of state law around privacy regulations as well. So it's really important that that word breach not even be brought into the conversation until the investigation has been completed. I think that when we talk about entities putting in their own breach notification requirement timelines, such as shorter than 60 days or things like that, one of the challenges with that is that I have seen forensic investigations that literally have machine time of analytics still running at 2 and 3 weeks because the data volume is so enormous to process. And so some of those types of nuances, again, the type of data, the format it's in, and how that data is handled are going to also contribute to how quickly you can perform your analysis and how quickly you can make those kinds of calls. The other thing too that I think is really important when we talk about breach notification. I go to a lot of conferences, I speak at a lot of conferences, and so I get to hear a lot of good speakers, and occasionally I get to hear some folks that you know, through the course of maybe trying to sell a widget, are kind of putting some information out there that's maybe unclear. One of the most important things is that when people start to talk about how business associates now must notify, they must notify the covered entity. That's really, really important because I've heard that left off so many times. And for some of you on this call, you're kind of going to be thinking, you know, this is kind of one of those Captain Obvious things where, of course. But I'm of the belief, based on the misinformation that I see on a pretty regular basis, we are going to have a scenario in the not too distant future where a business associate mistakenly believes that their obligation is to notify either OCR or to notify patients, which is going to cause all kinds of problems, public relations nightmares, and potentially trigger unwanted attention from the OCR because the business associate has triggered something when their only obligation was to notify the covered entity and do it in the way that their business associate agreement specified. So I think that that's a great place for Renee to jump in and talk about, you know, what should those provisions look like around notification between the BA and the covered entity?
Well, you're right on the spot there, Angie, with what you're talking about. I mean, unless you have gone through the process of experiencing a real data breach, you don't really have a feeling for how much of a public nightmare that is, and for your reputation, how upsetting it is for your patients or your clients to hear about it, the turmoil that it can cause within an organization, and the expense and the personal capital, et cetera, that is diverted towards dealing with the clients or the patients who have experienced the breach. When I draft my business associate, and this is the other thing, I want to get back to your notice issue. I have seen, as a covered entity, some notice provisions that actually say that the business associate has to notify the covered entity of a breach within 24 hours. And I've fought back against that and said, how could the business associate possibly know within 24 hours what it is they're dealing with? And this is when it gets into the distinction that you've made: what's an event, what's an incident, and what's a breach. And we went over this with the initial webinar. There's an analysis that needs to be done by the covered entity and that has to be documented by the covered entity, that involves, 4 questions as to whether or not a breach has actually occurred. And you can't make that determination until your investigation has been fully completed. So I always include in my business associate agreements that the business associate, that it follows the HIPAA language exactly, that the BA is to notify the covered entity of this possible event, incident, or breach within, 3 to 4 business days, with the understanding that the investigation is still ongoing. I generally include language that the BA will cooperate with the covered entity and take direction from the covered entity in dealing with the notification or in dealing with clients. Let's say the follow-up activities that have to occur regarding the credit the credit checks, etc. There's nothing worse than having a client hear about that from some unknown entity, because they don't know. Most clients don't even know about a business associate. So the last thing you want is to have them getting a call from Company X and they don't even know who Company X is, And the first thing they're going to say is, well, why the heck did you have my personal information, et cetera, et cetera. So it's really important that the relationship between the covered entity and the patient or the client is maintained to the best of the covered entity's ability, and that they drive that information bus. And that's just absolutely crucial to the whole process.
Yeah, and Renee, one of the things I'd like to point out as well is that in today's day and age of all of this merger and acquisition activity going on in the healthcare space, these kind of rules of the road need to be mapped out in all kinds of other agreements as well when covered entities are dealing with each other, because you can have a covered entity that has a breach but has actually potentially never even seen the patient. And so while it may be that covered entity's duty to notify, the covered entity that actually sees the patient and has the relationship with the patient, they're really the people from a PR perspective that need to be the face of the notification. And so those are some of the other nuances where this is not just about covered entities and business associates and subcontractors. This is also about the relationship between different types of covered entities as well. And this is one of the reasons why I'm so excited about our third and final webinar, because we are actually going to talk about real world scenarios that you and I, Renee, have lived in, where we're going to, change the names to protect the guilty and get to really kind of talk about all of these different nuances.
I agree. That's a good point. And, we're talking about due diligence with business associates, but that's part of the due diligence for covered entities acquiring another covered entity. And the most typical way I can see that happening is when a physician practice gets acquired by a hospital system, and now they're an employee of the hospital system, and sort of, as you're saying, who are they going to get the call from? Is it going to be Dr. Joe, or is it going to be somebody in the privacy office or from the hospital? So that's a very good point that you raised. I guess we're ready for the next slide, Angie.
Okay. So this is a lot of information, and we're getting near the end, so I really appreciate everybody staying with us, because I do want to leave some time for some question and answers. So I kind of want to summarize here, and I really think, there's some important points to take from this webinar. You have the basic 10 parts of the business associate agreement that you can start with, but then it's really looking at can you and should you customize your business associate agreements? I think, we heard a unanimous yes here. It's also looking at who really are your business associates, and looking at how will you assess them. And if you're a business associate, on the webinar, it's learning from all of these points in terms of how the covered entity also looks at your relationship. So we hope that this was really helpful. Angie kind of gave away what we're going with on the next webinar, and we're really excited about it because it's really an opportunity for us to get kind of down and dirty and talk about, some real case studies of what Angie and Renee have seen happening out there. So we certainly hope that you're going to join us for that. Before we get to your questions, I also want to say we are going to send out to you the recording of this session, but we'll also send the link to the last session, and we're going to try to do that because we know we have some new attendees today. And then we're also going to make our mini assessment available to you for those of you who attended today, and some personal follow-up. So I hope that's really helpful for you. So let's go ahead and open it up to some questions. I know we have some coming in. If we don't get to your question, we'll definitely follow up with you, as I said at the end. So one of the questions coming over was, what was the data destruction reference policy again? So they weren't able to capture the numbers. Angie, I think that you referenced that.
Sure, sure. In terms of looking at vendor accreditation with some type of oversight, you're going to be looking for an organization that is AAA certified through the National Association for Information Destruction, giving preference to those vendors that carry the NAID downstream data liability coverage, which is underwritten by the Lloyd's of London syndicate to protect you in the event of a breach. As it relates to the actual industry kind of specification standard, the National Institutes for Standards and Testing, or Standards and Technology, which is also referred to as NIST, has an entire series of special publications which actually form the framework and the underpinnings of all of the technical requirements of HIPAA. And the specific one on data destruction is one called Special Publication SP 888 Revision 1. And for those people who say, well, HIPAA doesn't tell me how to configure my firewall. HIPAA doesn't tell me how I'm supposed to implement encryption. HIPAA refers to NIST, and NIST has dozens, if not hundreds, of special publications on every single one of these topics, from deployment of encryption, encryption algorithms, and cryptography, all the way through disposal of hardware that are great references. And one of the overarching NIST special publications is 853 Revision 4, which kind of gives the overall information security posture and kind of guidelines around an entire information security protocol.
Okay. I hope that answered that question. I'm going to try to get this next question right. So, can a business associate agreement have subparts of other covered topics needed in a contract? Or does the business associate agreement have to stand alone? And I'll kind of, to clarify that, they use doctors as testifying experts and have a contract for other items such as their hourly fee and required services. So can it be part of that, or does it have to stand alone?
In that particular case, I mean, the business associate as the expert is functioning in a very discreet way, and you can include it in the same agreement, but I generally like to keep them separate ideas and documents and refer the one to the other, and say that if there's any confusion about what's contained in the underlying services agreement, that the terms of the business associate agreement will prevail. But I think in that particular situation, since you're talking about an expert witness who's giving discrete testimony at a trial, that's really all they're going to have access to is the chart. So you'll be talking about the individual's fees. So I don't know that the two really mix well at all. So I would definitely keep them separate.
And Angie, I would just add that as an information systems auditor, when I come in to do a risk assessment or a risk analysis, either one, and I get to the part where I'm looking at business associate agreement, it is much quicker and much easier for me to evaluate the business associate agreement if it is a standalone agreement that references other agreements versus part of a giant other type of contract. And the general rule is that if you hire me to come in and do your information risk assessment or risk analysis, and it's easy for me to see it, interpret it, and understand it, then you're going to be in a much better position if you are subject to an OCR audit, or you would be subject to any type of civil litigation or state issues, because when auditors come in, make it easy on them, be kind to them, keep them comfortable, keep them happy, and it generally works out way better for you.
Okay. So I'm going to go ahead and ask one more question. We have about a minute left. So basically, to clarify, it looks like I'm still a little bit unclear. If it's a covered entity, do they have to have business associate agreements with all of their business associate subcontractors?
No. The business associate has the legal duty under HIPAA to enter into those agreements with their subcontractors. So the covered entity only has to have a business associate agreement with their business associate, and then if the business associate engages subcontractors, then that business associate has to enter into a business associate agreement with the subcontractor. So it's sort of like down the line.
Okay. And so probably could be part of an assessment to ask, do you have business associate agreements with all your subcontractors?
Correct.
I would go so far as to also ask the question, do you use subcontractors? Because that is kind of an unfortunate aspect of vendors, is that they sometimes don't reveal that they're using subcontractors. And some will go to great lengths to even cover that fact up. So just knowing that your business associate uses subcontractors, and I always advise that you really should have in a contract that you're going to force them to tell you when they're going to use subcontractors, if they're going to be using subcontractors, and that you kind of get a first right to to say no to particular subcontractors if you're in a position to negotiate with that much power.
Okay,
That's a good point.
excellent. All right, so I think I'm going to stop there and be respectful of everybody's time. And again, just to kind of summarize everything, you will hear from us with the recordings. Once you get the follow-up email, please feel free to correspond back and forth with us. We'll be in touch with you. We hope you found this valuable information today. And Angie and Renee, as always, we really appreciate your time in providing this to the audience.
Always my pleasure.
Yes.
All right. Thank you. We look forward to hearing you to having you on our next webinar. Thanks. All have a good afternoon.